what is it, litigation funding, and how does it work?
Got it. So if I back up a step to how do lawyers finance their firms? Lawyers traditionally finance their firms one of several ways. They self-finance, which in and of itself is debt. It's just their own. It's complete recourse because if they lose it, it's their money to lose and it's gone. There is banking. Banking has been around as long as any other business in the world. And that is a source that lawyers typically will have a line of credit with. And the other way that lawyers traditionally funded was by partnering or JVing with other firms, which, while it has its benefits to work with other firms, if they contribute all the capital and you don't, you end up giving away half or more of your fee. But those were the traditional ways that lawyers would finance their firms and their cases. What litigation finance is, which is also called alternative litigation finance, is when you have a group like Abridged that will look to the case collateral, right? Cases and future contingent fees that the firm has over the next 1 to 3 to 5 years. And it pulls some of those fees forward so that you can use them today to go out and market for more cases. You can use it to pay for case expenses. You can use it to expand your firm, hire more people, build out more office space, open new offices. And it does it in a way that permits you to retain as much of your fee as possible. And so that's what alternative litigation finance means. We were not born from banking. We were not born from investment banks or Wall Street, as it were. Edward had some experience on finance matters, and I was an attorney. And we came at this trying to create something that was new and that borrowed the best of all worlds to benefit lawyers, law firms, and most importantly, their clients. So that's what it is. I'm happy to explain how it works.
Yeah. Because, I get calls all the time from lawyers that have heard litigation funding over and over and over again, and will call me and say, well, how does it work? So you mean I need to give you something in order for you to give me this loan? Like, it's not like just applying at the bank. So I think it's important to keep emphasizing sort of the core use of litigation funding, how it works, and who is the best fit for it. Sure.
The best way I can explain it, I think, would be to talk about how we're different from a traditional bank.
Right.
When a lawyer goes to a bank, most often, for 95% of the lawyers, they're essentially borrowing their own money. The bank will say you have $1 million on deposit. We'll loan you that $1 million at 5%, and now go use it as a line of credit. And that line of credit, Morena, can be called year to year, right? They can call it or not renew it. The other things that banks like doing is getting a personal guarantee, not only from your business, but from you individually. And it covers your stock portfolio. It covers your second home. It covers, other assets that you have. Banks are not good at underwriting cases. They don't understand them. They'll ask you for case updates. They'll say, send us your case listing, but it's Greek to them. They don't know what they're looking at most of the time. What Abridged does is it looks at your case inventory, not your stock portfolio, not your personal assets. And those are what become the case collateral. So, for example, if a lawyer has 500 personal injury cases or 500 talc cases, Abridged would look at those, try to determine what the net fee interest of that lawyer or the firm is, and come at a valuation that allows us to advance capital. It's not a line of credit. If they borrow $1 million, it's loaned to them and put into their operating account at closing. And then they can use it, deploy it as they see fit for their legitimate business purposes. So that's really, when you boil it all down, how we are different. There's more to the story, of course, but that's essentially what we do.
Yeah. So what is Virage's traditional product? And is it just a one way where you underwrite, you see what the cases are, look like, evaluate, determine what you're going to offer against that collateral? Or is there other things where, you can be creative with how you're lending, how many parties can be involved, and things of that nature?
Great question. So I'll tell you that the main thrust of what we do is that a law firm, whether it's one or two partners or 10 partners, whether it's an AmLaw 100 firm getting into contingency fee work, or it's a 20 or 30 year mass tort firm or personal injury or other litigation boutique. And they will say, we have a basket of cases, and we will determine what is the ask. What is the amount of money the firm is looking for, and what does it need? Sometimes a firm will say, we want $10 million. And we come to find it's really only 2.5 a quarter if they need it that often. It may be 2.5 a quarter, but it's spread out now over 2 years, not 1 year. When you have a lender asking you to take less than more, I think you've got an honest and a good partner in that lender. So the lawyers will give us their basket of cases, and we will underwrite them. And we do that internally. We do not use a third party. Right. We have lawyers on staff, and through my experience and other team members, we will evaluate the cases. We will also underwrite the law firm and the lawyers. The reality is we're not right for everybody. Just as we're not right for everybody, not everybody's right for us. Yeah. But assuming there's a match after we underwrite with the lawyers, we underwrite the cases, we will then make an offer for a loan. And that loan is at a stated interest rate. And that interest rate varies based on whether it's a pre-settled docket, or some of the collateral is pre-settlement, or whether it's post-settlement, awaiting lien resolution, awaiting a QSF administrator, qualified settlement fund administrator, to pay out the monies. We look at whether a lawyer is an aggregator of cases, or the trial law firm, or the settling counsel, or are they in a joint venture with all of those together? Because what I think lawyers need to look at when taking financing is, it's good that you have 1,000 cases, but are you in control of your data? Are you in control of your case? Are you in control of reporting that you need? Set aside for a lender. You need it so that you know what your cases are worth, because $1 today is worth something different in 3 years from now or 7 years from now. So we come up with an offer, and then we will send that law firm a loan document. We're happy to send a term sheet if they want, but I prefer the loan document because that's where the details are. And by the time we get there, through help from people like you who work with so many great firms and work with us and others, we come to terms fairly quickly, and then we close. And so that's the process.